These security needs persist today. Many hostages, including Americans, are still being wrongfully held in horrendous conditions. These are grave circumstances, and they warrant careful attention. But the General Assembly's expedited request, and therefore this advisory proceeding, focuses solely on a request to identify legal obligations. It is not about adjudicating the facts or determining legal consequences. The United States submits that what is before the court is a legal question consisting of two narrow legal issues, and that the answers are clear under well-established rules of international law. These answers would apply regardless of the particular state under consideration. The first issue focuses on the obligations of an occupying power, and the second focuses on the obligations of a UN member state. Mr. President, members of the court, allow me to first address the obligations of an occupying power to the United Nations, international organizations, and third states with respect to humanitarian assistance. International law does not impose any unqualified obligations on an occupying power regarding all these entities, much less any particular entity. The applicable international rules have been carefully developed through state consent to treaties and customary international law. As the court repeatedly recognized, international humanitarian law is the lex specialis governing the obligation of parties to armed conflict. Within that lex specialis, it is the law of occupation that establishes an occupying power's specific rights and obligations. Before diving into the particular obligations of any occupying power, we should step back to understand the context for why states have agreed to specific rights and duties in occupation law. As the court has previously observed, occupation is a question of fact, and occupation law describes the rights and responsibilities for administering control over occupied territory. An occupying power has obligations related to maintaining public order and safety and protecting the civilian population. It also has the right, while an occupier, to pursue its military objectives and govern enemy territory. In the law of occupation, therefore, military and humanitarian interest converge. This means that where specific provisions of that law call on an occupying power to provide the civilian population with relief, the occupying power does not lose its right to ensure its own security. With this framing in mind, I will address the specific limited obligations of an occupying power toward third states and organizations in two categories. First, obligations on allowing and facilitating relief for the civilian population, and second, rules relating to the impartiality of humanitarian organizations. In both categories, occupation law preserves an occupying power's discretion to address its security interests, including the ability to curtail the activities of third states or organizations that are contrary to its security. For the first category, most submissions to the court address the Fourth Geneva Convention of 1949. Article 59 of the Fourth Geneva Convention states that when the population of the occupied territory, quote, is inadequately supplied, the occupying power shall agree to relief schemes on behalf of the said population and shall facilitate them by all the means at its disposal. Several submissions incorrectly assert that this means that Article 59 requires an occupying power to agree to all relief offered by all outside organizations. But the text of Article 59 contains no such expansive language, nor does it prescribe which relief schemes an occupying power must consent to. The only mention of third parties comes in the next paragraph of Article 59, which states, quote, such schemes which may be undertaken, either by states or by impartial humanitarian organizations, such as the International Committee of the Red Cross, shall consist in particular of the provision of consignments of foodstuffs, medical supplies, and clothing, end quote. The word impartial is obviously important, and I will return to it. But for now, focus on the fact that this provision is actually a definition of what a relief scheme provides. That is, food, medical supplies, and clothing. The language on third parties merely describes possible providers of relief, which is clear from the words may and such as before the example of the International Committee of the Red Cross. It is also critically important that Article 59 does not remove an occupying power's authority to ensure public order and safety in the territory. In other words, an occupying power retains a margin of appreciation concerning which relief schemes to permit. Thus, even if an organization offering relief is an impartial humanitarian organization, and even if it is a major actor, occupation law does not require an occupying power to allow and facilitate that specific actor's relief operations. An occupying power may also fulfill its humanitarian obligations toward the civilian population while advancing its own military and security interest. An example can be found in Article 55 of the Fourth Geneva Convention. Article 55 describes the obligation of an occupying power to ensure the food and medical supplies of the population. But as the ICRC commentary explains, under Article 55, quote, "The occupying authorities retain complete freedom of action in regard to this, and are thus in a position to take the circumstances of the moment into account," end quote. Similarly, while Article 63 recognizes that National Red Cross societies and other relief societies are permitted to continue their humanitarian work under Red Cross principles, an occupying power may still impose restrictive measures for urgent reasons of security. I turn now to the second category, which is a fundamentally important limitation built into occupation law. Articles 59 and 61 of the Fourth Geneva Convention make clear that collective relief may be conducted by third states or, quote, impartial humanitarian organizations. As many submissions acknowledge, impartiality requires that humanitarian relief be distributed in a non-discriminatory manner. However, the concept of impartiality in the phrase impartial humanitarian organization also refers to taking no side in the armed conflict. The ICRC commentary to Article 59 makes this clear. It says that, quote, "Only those states which are neutral are capable of providing the essential guarantees of impartiality," end quote. And the commentary to Article 61 shows that the term impartiality in describing organizations providing relief is synonymous with neutrality. Here, there are serious concerns about UNRWA's impartiality, including information that Hamas has used UNRWA facilities and that UNRWA staff participated in the October 7th terrorist attack against Israel. Israel, therefore, has ample grounds to question UNRWA's impartiality. Some have argued that the evidence is insufficient, or that the UN's investigation and the Kelowna report have resolved concerns about UNRWA. But the Kelowna report itself recognizes that, quote, neutrality-related issues persist for UNRWA, and that there continue to be serious challenges with respect to UNRWA's oversight and accountability. Again, the court need not and should not reach these factual issues. But given these concerns, it is clear that Israel has no obligation to permit UNRWA specifically to provide humanitarian assistance. UNRWA is not the only option for providing humanitarian assistance in Gaza. In sum, There is no legal requirement that an occupying power permit a specific third state or international organization to conduct activities in occupied territory that would compromise its security interest. To hold otherwise would be contrary to the Fourth Geneva Convention. Mr. President, members of the Court, I turn now to the obligations of Israel as a UN member state. The Security Council and General Assembly have worked for decades toward an end to the conflict between Israel and the Palestinians. Throughout that long history, Israel has hosted and engaged with the UN agencies, and UN representatives. Some participants have argued that this engagement has resulted in or arisen out of additional obligations on Israel solely by virtue of Israel's membership in the United Nations. Those arguments rest on mischaracterizations of the UN Charter. The General Assembly gives Israel a perpetual obligation to cooperate with UNRWA. This is a fundamental principle that is distinct from any obligations Israel or any UN member state might have toward a UN entity that it agrees to host. This is because the UN Charter codifies an allocation of power and responsibilities among its principal organs, particularly between the Security Council and the General Assembly. That allocation was deliberately chosen by the drafters and is central to the United Nations approach to advancing international peace and security. This Court's prior opinions, both in competence of the General Assembly and in certain expenses of the United Nations, remind us that in interpreting the Charter, the Court considers the relationship that the Charter establishes between the General Assembly and the Security Council. This structure has paramount importance. Yet many arguments in these proceedings would upset this structure, including the suggestion that Article 2, Paragraph 5 of the Charter effectively confers upon the General Assembly powers reserved in the Charter for the Security Council. That is incorrect. Article 2.5 states in relevant part that, quote, all members shall give the United Nations every assistance in any action it takes in accordance with the present Charter. This clause does not mean that resolutions by the General Assembly form binding obligations on member states. The Charter carefully defines the responsibilities that are unique to the Security Council. Under Article 39, only the Security Council can decide what measures, quote, shall be taken by UN member states to maintain or restore international peace and security. And only the Security Council can make the threat determination that must precede such binding decisions. In addition, such decisions require not only that at least 9 Security Council members vote yes, but also that the 5 permanent members either vote yes or abstain. Unlike the Security Council, the recommendations and activities of other UN organs, including the General Assembly, do not themselves have authority to bind UN member states. The Charter is clear as to the limits of the General Assembly's powers. Under Article 10, the General Assembly may make recommendations to the members of the United Nations. And under Article 14, the General Assembly, quote, may recommend measures for the peaceful adjustment of any situation, end quote. In sum, while the General Assembly may make recommendations, it may not order coercive action. Straining international law to expand the General Assembly's powers, as some have suggested here, would serve only to weaken the foundations of international law. This Court has also recognized the Security Council's unique role under the UN Charter. For example, in the certain expenses case, the Court explained that, quote, it is the Security Council which is given a power to impose an explicit obligation of compliance, and, quote, It is only the Security Council which can require enforcement by coercive action, end quote. And the court itself has interpreted action to mean coercive or enforcement actions, as in Article 11, Paragraph 2 of the UN Charter. While the court also indicated that measures recommended by the General Assembly under Article 14 implies some kind of action, it did not do so in the context of determining the scope of Article 2.5. Some suggest that Article 2.5 is not limited to enforcement actions by the Security Council, but they do not account for the fact that the Charter does not use the word action in describing the General Assembly's powers to make recommendations on questions relating to the maintenance of international peace and security. Nor do they account for the negotiating history of this article, which is explained in the United States written submission. The attempt to expand Article 2.5's meaning would also be contrary to the practice of the United Nations with respect to other entities that the General Assembly has created. The court emphasized this in the certain expenses case when it pointed to the UN Secretary General's statement that, quote, while the General Assembly is enabled to establish force with the consent of those parties which contribute units to the force, it could not request the force to be stationed or operate on the territory of a given country without the consent of the government of that country. Some have pointed to what they consider to be precedents in arguing for a wider role for the General Assembly, but these are easily distinguishable. The situation here is not parallel to Namibia, where the UN General Assembly acted in conjunction with binding UN Security Council resolutions. Nor does the question before the court involve the responsibilities assigned to the General Assembly, which the court considered in certain expenses. There, the court found that the General Assembly had the power to take decisions to approve the budget of the organization. That case is clearly distinct because the General Assembly was acting under express authorization in the UN Charter to make certain decisions on budgetary matters. The reparations case stands for nothing different. In that case, this court affirmed that the United Nations is an international organization imbued with the powers essential to the discharge of its functions, including the capacity to claim appropriate reparation for damages suffered. The case has been repeatedly cited by the court for that limited proposition. And while the court referred to the importance of Article 2.5 to the effective functioning of the UN, the court expressed no opinion or analysis as to the scope of obligations incurred by the member states under that article. In the reparations case, the Charter was silent on the issue before the court. Yet here, the Charter is clear that the General Assembly lacks the power to impose binding obligations on UN member states. Other participants suggest that the court should interpret Article 2.5 expansively by reference to other articles in the Charter, the principle of good faith or the duty to cooperate. The United States respectfully submits that the court should reject the proposition that Article 2.5 transforms the recommendations of the General Assembly into binding obligations. The obligations under the UN Charter must be implemented in good faith, but good faith does not obligate a UN member state to take specific measures in the absence of a decision by the Security Council that particular action is necessary. In this case, the Security Council has not adopted a binding resolution that Israel must cooperate. A Security Council decision, individual member states have flexibility to determine appropriate measures consistent with applicable law. They can give due consideration to the recommendations of UN organs, but such recommendations plainly are not binding. The court should also decline to find that a general purpose of the United Nations, such as under Article 1.3 of the Charter, may impose a specific legal obligation on a UN member state. As the court made clear in the certain expenses case, it is necessary to distinguish between the purposes of the United Nations and the powers conferred to effectuate those purposes. These powers are not unlimited. Nor should the court reinterpret Article 2.5 on the basis of Articles 55 or 56 of the Charter. Article 55 provides objectives for the United Nations to promote. Article 56 then provides for a generalized commitment to cooperate with the United Nations in pursuit of the objectives in Article 55. Neither of these articles compels, much less lists, particular actions for the organization or its member states to undertake. These articles were not intended to infringe upon member states' authority to determine how to advance these objectives of the United Nations. Mr. President, members of the court, before I conclude, I would like to make three overarching observations about the question referred to the court in this advisory proceeding. First, it cannot escape notice that the request follows the regrettable precedent of seeking advice with respect to the obligations of only one of the parties to the underlying conflict. We are all well aware that less than a year ago, the court provided its advice on a broad set of questions focused one-sidedly on Israel and its activities. Second, the General Assembly has simply asked the court to identify the obligations of Israel. The narrow framing of the question is important because the court has related contentious proceedings before it, including with Israel as a party. This means that, consistent with the narrow scope of the question, there should be no finding either as to compliance with any obligations identified in this proceeding or as to the legal consequences of any alleged breach. Third, the question is limited to identifying those obligations in relation to the presence and activities of the United Nations, other international organizations, and third states. While there certainly are rules of international law relevant to the population of an occupied territory, those were addressed in the court's July 2024 opinion and do not need to be revisited. Similarly, the court has recently advised on the right to self-determination in this context. The question before it here does not require revisiting the analysis of that right. In concluding my remarks, let's return to the principles I began with. The question before the court in this proceeding is, by definition, a legal question. The General Assembly has asked the court to identify a set of obligations, and that is all. We also urge the court to bear in mind that the rules applicable in this context apply globally and to all states. Some have asked you to identify sui generis responsibilities for Israel, or even a sui generis responsibility tied to UNRWA. Identification of such novel obligations would be inconsistent with international law, including the UN Charter. Novel legal interpretations will not bring an end to the ongoing conflict. They will not bring the hostages home. They will not create a better tomorrow for Israelis, Palestinians, and the region. To be clear, the United States supports the flow of humanitarian aid into Gaza, with safeguards to ensure it is not looted or misused by terrorist groups. We encourage the international community to focus on advancing a ceasefire and on fresh thinking for a better future for Israelis and Palestinians alike. Mr. President, members of the court, this concludes the oral statement of the United States. Thank you for your attention.
I thank the representative of the United States of America for his presentation. I now invite the next participating delegation, the Russian Federation, to take the floor. And I call Mr. Maxim Mishkin to the podium. You have the floor, sir.
Mr. President, Madam Vice President, members of the Court, it is an honor to address the Court, the principal judicial organ of the United Nations, on behalf of the Russian Federation. Today, we confront a crisis of legality and humanity in light of systematic undermining of the United Nations Relief and Works Agency for Palestine refugees by Israel and its negligence towards the overall obligations under international law, including those stemming from the status of Israel as an occupying power. The urgency of this matter cannot be overstated. Gaza balances on the brink of famine, hospitals lie in ruins, millions of Palestinians in the Strip, as well as in the West Bank, including East Jerusalem, face existential despair. Mr. President, the General Assembly's request for an advisory opinion, adopted by 137 states in Resolution 79-232, is based on Article 96 of the UN Charter and Article 65 of the ICJ Statute. These articles provide for the advisory jurisdiction of the Court. Some states, including Israel, in their written statements have argued that this request is politically charged, concerns bilateral relations, and the subject of the ongoing proceedings between South Africa and Israel on application of the Genocide Convention. This is not the first time the Court considers the relevant aspects of the conflict between Israel and Palestine. The Court's 2004 Wall Advisory Opinion and 2024 Opinion on the Policies and Practices of Israel in the Occupied Palestinian Territory, including East Jerusalem, established irrefutable precedents. In 2004, the Court affirmed that Israel's construction of the wall violated international humanitarian law. In 2024, it reaffirmed Israel's status as an occupying power in the Palestinian territory, including the Gaza Strip. These opinions constitute a solid foundation for facilitating peace in the region and ensuring the rights of Palestinians to self-determination, as well as providing for legal qualification of Israeli actions. They also serve as a basis for the present request of the United Nations General Assembly. Today, we address a new dimension: Israel's October 2024 laws banning UNRWA's operations, which, in our view, directly contravene the norms of IHL, the UN Charter, and the 1946 Convention on the Privileges and Immunities of the United Nations. Under Article 30 of the latter, disputes over its interpretation must be referred to this Court. Thus, the Russian Federation invites the Court to follow its own reasoning on jurisdiction and discretion to hear the present case used in 2024 advisory opinion, since the factual and legal background of these cases are quite similar. Besides, the question put before this Court is strictly legal. It concerns Israel's duties as an occupying power under IHL and its obligations to uphold the privileges and immunities of the UN agencies, other international organizations, and third states in and in relation to the occupied Palestinian territory. Therefore, we maintain that judicial restraint here would undermine the very architecture of international law. Mr. President, to understand the importance of this moment, we must reflect on history. Established in 1949 by General Assembly Resolution 302, UNRWA was created to address the catastrophic displacement of 750,000 Palestinians. Today, it serves 5 1.9 million Palestinian refugees across Gaza and West Bank, Jordan, Lebanon, and Syria. For 75 years, UNRWA has been more than just an aid agency. It is a symbol of international community's collective responsibility to the Palestinian people, striving for a state of their own, in exercise of their right to self-determination, in accordance with international law, and return. The role of UNRWA in facilitating the humanitarian aid is crucial, and its work is strongly supported by the vast majority of the international community. Agency's mandate, education, healthcare, and emergency relief is not mere charity. These spheres are legal obligations of the occupying power under ICJ. When Israel occupied Gaza and the West Bank in 1967, it inherited the duty to ensure the welfare of the population on the occupied territory. Instead, this responsibility was outsourced to UNRWA and other UN agencies and programs, relying on the agency's schools, clinics, and distribution networks to mitigate the humanitarian impact of Israel's own policies. In Gaza, as mentioned in the United Nations Security Council press statement of the 30th October 2024, UNRWA remains the backbone of all humanitarian response, and no organization can replace or substitute UNRWA's capacity and mandate to serve Palestinian refugees and civilians in urgent need of life-saving humanitarian assistance. Now, with the resumption of Israel's military operation in Gaza, together with the imposition of a total blockade since the 2nd of March, the Strip has continued to endure devastating destruction and a humanitarian catastrophe of unprecedented scale. The West Bank, where Israel has launched its full-scale military operation on the 21st January, risks repeating terrible Gaza scenario. UNRWA's installations and personnel are under attack there too, as well as in East Jerusalem, where after the enactment of the Knesset bills on the cessation of UNRWA's operations, all the offices, including the historic premises Sheikh Jarrah and Kalandia, operated since 1950, were arbitrarily closed. By doing so, Israel, for the first time in history, unilaterally prohibited the work of the United Nations Agency and deprived it of its privileges and immunities. It is also worth mentioning here that this year, UNRWA has been again nominated for the Nobel Peace Prize. Awarding this prize will obviously be timely and well-deserved, taking into account the highest price the agency has paid during the recent crisis in the Middle East. Israeli military operations claimed lives of 290 of UNRWA's staff members. To this effect, Russia has been consistently advocating for an unconditional and sustainable ceasefire, the release of all hostages and detainees, safe and unhindered humanitarian access, as well as the restart of the peace process on a universally recognized international legal basis with two-state solution formula at the center. Mr. President, it is the position of the Russian Federation, which is based entirely on the advisory opinions of the Court of 2004 and 2024, that Israel, as the occupying power, is bound by the ICJ, including the Fourth Geneva Convention and the Hague Regulations. The Court observed in the Wall advisory opinion that in the 1967 armed conflict, Israel occupied the territory between the so-called Green Line and the former eastern boundary of Palestine under the British mandate, namely the West Bank and East Jerusalem. The situation since then has not improved, but rather deteriorated, According to the 2024 advisory opinion, Israel's withdrawal from Gaza Strip has not entirely released it of its obligations under the law of occupation. Therefore, Israel, to this day, remains an occupying power in terms of ICJ, and its relevant rules and principles are fully applicable to Israel. We consider the following provisions of ICJ as especially pertinent to the case in hand. Under Article 43 of the Hague Regulations, and I quote, "The occupant shall take all the measures in his power to restore, to ensure as far as possible public order and safety." End of quote. Under the court's interpretation in the opinion of 2024, this includes the duty to administer the territory for the benefit of the local population. Article 50, paragraph 1 of the Fourth Geneva Convention provides that the occupying power shall, with the cooperation of the national and local authorities, facilitate the proper working of all institutions devoted to the care and education of children. Article 55, paragraph 1 of the Fourth Geneva Convention further provides that, and I quote, "To the fullest extent of the means available to it, the occupying power has the duty of ensuring the food and medical supplies of the population. It should, in particular, bring in the necessary foodstuffs, medical stores, and other articles if the resources of the occupied territory are inadequate." End of quote. Article 56, paragraph 1 of the Fourth Geneva Convention provides that, and I quote, "The occupying power has the duty of ensuring and maintaining the medical and hospital establishments and services, public health, hygiene in the occupied territory." End of quote. Article 51 obliges Israel to facilitate humanitarian relief schemes by all the means at its disposal, if the whole or part of the population of an occupied territory is inadequately supplied. None of that is happening today. As stated in the UN Secretary General's press encounter on Gaza of the 8th of April 2025. Israel and its supporting states claim that other agencies can replace UNRWA, and the occupying power has discretion to determine whether, when, and to what extent other parties may be present and operate in the occupied Palestinian territory. We respectfully ask the court not to follow this line of logic. Firstly, no organization possesses UNRWA's infrastructure in the Gaza Strip and the West Bank. 65 clinics, 12 food distribution centers in Gaza, and 30,000 local staff. Without UNRWA, Gaza's humanitarian system will collapse. And secondly, the mentioned before Article 59 of the Fourth Geneva Convention unequivocally obliges the occupying state to agree to the relief schemes on behalf of the said population. The Fourth Geneva Convention not only lays down that the occupying power must agree to the said relief schemes, but insists that it must facilitate them by all the means at its disposal. The occupation authorities must therefore cooperate wholeheartedly in the rapid and scrupulous execution of these schemes. Israel claims its laws on UNRWA are necessary for national security. Israel has the right to ensure its own security. But the path to this goal lies exclusively through a comprehensive Middle East settlement process and the realization of the legitimate right of Palestinians to their own state within the borders of 1967, with East Jerusalem as its capital. The right derives from one of the fundamental principles of the United Nations Charter, the right to self-determination of peoples. Even so, the security concerns do not absolve Israel from other norms of international law, including the norms on privileges and immunities of international organizations. Furthermore, the Fourth Geneva Convention in its Article 59 provides for safeguards that the relief consignments may be searched by the occupying power. UNRWA has cooperated with the Israeli authorities for decades, sharing staff lists, facilitating aid coordination, and conducting a thorough audit, the results of which are available to the public. We maintain that security issues should be subject to substantive cooperation and discussions between Israel and UNRWA to mitigate these concerns. Since the laws on the cessation of UNRWA operations also prohibit all contacts between Israel's government and UNRWA, the much-needed negotiations are stalled on the part of Israel. Given the crucial role UNRWA has played in over 75 years of its activities in the region, on behalf of the Palestinians, the cessation of its operations will result in the catastrophic scarcity of supplies and assistance to the population of the occupied Palestinian territory, including refugees in the neighboring countries, Jordan, Lebanon, and Syria. Israel's laws on the prohibition of the work of UNRWA will undoubtedly worsen the humanitarian situation in the occupied Palestinian territory and will make the population in the said territory inadequately supplied, the language used in Article 59 of the Fourth Geneva Convention. The role of the agency in providing complex assistance to the Palestinians is crucial to ensure their fundamental rights, including the cornerstone UN Charter right to self-determination, within the two-state solution framework. Mr. President, turning to the issues of privileges and immunities, the Russian Federation submits that UNRWA's legal status is clear. As a subsidiary organ of the General Assembly under Article 22 of the UN Charter, with a clear humanitarian mandate, it is entitled to privileges and immunities under the 1946 Convention. Furthermore, according to Article 105 of the United Nations Charter, the organization shall enjoy in the territory of each of its members such privileges and immunities as are necessary for the fulfillment of its purposes. Israel's October 2024 laws revoking UNRWA's immunities, criminalizing its staff, and seizing its assets constitute a violation of this framework. In no way do the provisions of the UN Convention of 1946 allow the unilateral revocation of privileges and immunities. The privileges and immunities of the United Nations play an important role in ensuring the functioning of this organization. They are necessary to fulfill the basic functions of the United Nations, such as maintaining peace and security, promoting international cooperation, and protecting human rights. Privileges and immunities allow the United Nations to carry out its activities freely, without fear of persecution by states or individuals. This ensures the independence and impartiality of the organization in carrying out its tasks. Israel's legislation is not merely unlawful, it is an attack on the UN fundamental principles. If tolerated, it sets a very dangerous precedent for states to dismantle any UN agency they deem inconvenient. Within the broader context of Arab-Israeli conflict, it is necessary to highlight that other UN structures, UNFIL and UNDOF in Lebanon and Syria, have also been negatively affected and obstructed by Israeli invasions and continued unlawful military presence. In a more broad context, United Nations and missions of states to the UN were also impacted. There were numerous violations by Biden and the Obama administrations of the agreement regarding the headquarters of the United Nations of 1977 and the UN Convention of 1946. Part of the official premises of the Russian mission in the United Nations in New York was blocked. Issuance of visas of the state representatives for meetings under the auspices of the United Nations and of the UN staff members of specific nationality was deliberately hindered. Movement restrictions were put into effect. Similar violations regarding issuance of visas are committed by France as the host country of UNESCO. The erosion of privileges and immunities strikes at the heart of multilateralism, undermining the UN's capacities. Mr. President, Madam Vice President, members of the Court, this case transcends legal technicalities. UNRWA's collapse would not only doom millions of Palestinians, it would shatter the credibility of the UN system. Therefore, the Russian Federation respectfully submits the following. First, in our opinion, the Court has jurisdiction to give the advisory opinion requested by the General Assembly. Second, we believe that there are no compelling reasons for the Court to exercise its discretion not to consider the question posed by the General Assembly. Third, Israel, as the occupying power, has the obligation not to impede the Palestinian people from exercising its right to self-determination. Fourth, as the occupying power, Israel is obliged under ICJ to ensure and facilitate the unhindered provision of humanitarian aid and assistance to the Palestinian population. Fifth, due to the unique role of UNRWA in the occupied Palestinian territory, Israeli laws on the prohibition of the agency's activities violate IHL norms and principles. Implementation of these laws will undoubtedly worsen the humanitarian situation for Palestinian population and significantly hinder the realization of the Palestinian people's right to self-determination. And sixth, the passing laws on UNRWA, bypassing laws on UNRWA, Israel unilaterally deprives UNRWA of its privileges and immunities, which is a violation of the United Nations Charter and the Convention on Privileges and Immunities of the United Nations of 1946. Mr. President, Madam Vice President, members of the Court, let this Court's opinion be a beacon of hope, a reaffirmation that international law and not the so-called rules-based order governs actions of states and international organizations. Thank you for your attention.
I thank the representative of the Russian Federation for his presentation. J'invite à présent la délégation suivante, celle de la France, à prendre la parole et appelle à la barre Monsieur Diego Cola. Monsieur, je vous en prie.
Merci, Monsieur le Président. Monsieur le Président, la France souhaite tout d'abord vous féliciter pour votre élection à la présidence de cette Cour. Monsieur le Président, Mesdames et Messieurs les juges, ma présence devant vous s'inscrit dans la continuité des efforts déployés par mon pays pour mettre un terme à la situation humanitaire désastreuse dans la bande de Gaza et plus généralement dans l'ensemble du territoire palestinien occupé. La France regrette les grandes difficultés d'accès à l'information fiable dues aux graves attaques dont sont victimes un nombre croissant de journalistes. Pour autant, les informations qui nous parviennent de Gaza sont alarmantes. Au 24 avril, selon les chiffres du ministère de la Santé de Gaza, le bilan humain de la guerre était de plus de 51 300 morts et de 117 000 blessés. Il convient en outre de signaler l'interruption totale de l'aide humanitaire depuis le 2 mars. L'épuisement des produits essentiels, y compris des stocks alimentaires, ainsi que la violence des opérations militaires dont beaucoup touchent les civils et les travailleurs humanitaires. S'agissant de ces derniers, 418 d'entre eux ont été tués depuis octobre 2023, dont 290 personnels de l'Office de secours et de travaux des Nations Unies pour les réfugiés de Palestine dans le Proche-Orient, que j'appellerai ci-après l'UNRWA ou l'Office. Face à cette situation, que la France ne cessera de condamner, sa position restera ferme et constante. L'aide humanitaire doit parvenir massivement à Gaza. Les restrictions à son accès doivent être levées sans délai. L'ensemble des points de passage doivent être ouverts. Le travail des acteurs humanitaires doit être facilité et leur personnel doit être protégé conformément au droit international. C'est dans ce contexte d'urgence que s'inscrit la présente procédure. Celle-ci permettra à la Cour de clarifier les obligations d'Israël relatives à la présence et aux activités humanitaires dans le territoire palestinien occupé et en lien avec celui-ci, à l'appui du droit du peuple palestinien à l'autodétermination. La question posée à la Cour appelle 4 remarques liminaires. Premièrement, elle porte sur les obligations d'Israël. Partant, il reviendra à la Cour d'identifier précisément ces obligations et les conditions de leur respect. La question ne mentionne pas explicitement, comme c'était le cas pour d'autres demandes d'avis, les conséquences juridiques d'un comportement donné. Pour autant, l'Assemblée générale, qui a demandé l'avis, et les États devront en tirer toutes les conséquences. Deuxièmement, la question posée fait référence aux activités d'autres organisations internationales. Au regard du rôle essentiel des organisations non gouvernementales, telles que Médecins du Monde ou Action contre la faim, dans le territoire palestinien occupé, la France considère que leurs activités doivent aussi être prises en compte dans le cadre de la présente procédure. Toutefois, dans le temps imparti et au regard des circonstances factuelles à l'origine de la saisine de la Cour, mon exposé portera principalement sur la présence et les activités de l'UNRWA. Troisièmement, du fait de l'expression « en lien avec celui-ci », la portée territoriale de la question n'est pas limitée au seul territoire palestinien occupé. Cette formulation invite en effet la Cour à examiner les obligations internationales dont Israël doit s'acquitter sur son propre territoire, dans la mesure où leur exécution serait susceptible d'emporter des conséquences sur le territoire palestinien occupé. Enfin, la France a constamment rappelé l'importance du respect du droit à l'autodétermination du peuple palestinien. Son exercice a, selon elle, pour seul horizon possible une solution à 2 États, la seule qui puisse garantir la paix et la sécurité sur le long terme aux Israéliens et aux Palestiniens. Comme mon pays l'a déjà souligné, la fourniture de l'aide humanitaire et de l'aide au développement permet d'établir les conditions pour que le peuple palestinien puisse être en mesure d'exercer son droit à l'autodétermination. Cette aide participe donc pleinement de l'exercice du droit des Palestiniens à disposer d'eux-mêmes. Monsieur le Président, Mesdames et Messieurs les juges, à la lumière de ces éléments introductifs, ma plaidoirie détaillera successivement les obligations d'Israël qui découlent de sa qualité d'État membre des Nations Unies, premièrement, puis celles qui découlent de sa qualité de puissance occupante dans le territoire palestinien occupé, deuxièmement. Il est important de souligner que ces obligations ne sont pas exclusives les unes des autres. Elles sont au contraire simultanément applicables et se nourrissent mutuellement. Pour ce qui est des obligations issues du droit des Nations Unies, j'aborderai d'abord les obligations générales d'Israël à l'égard de la présence et des activités de l'UNRWA dans le territoire palestinien occupé et en lien avec celui-ci, premièrement, puis plus spécifiquement, les privilèges, immunités et facilités dus à l'Office en tant qu'organe de l'ONU, deuxièmement. À titre liminaire, il doit être rappelé que, comme pour tout organe subsidiaire de l'Assemblée générale des Nations unies, la présence et les activités de l'UNRWA sur un territoire donné sont soumises au consentement des parties intéressées. Israël et l'UNRWA ont conclu plusieurs accords, dont un accord concernant une assistance aux réfugiés de Palestine, entré en vigueur le 14 juin 1967, que j'appellerai ci-après l'accord de 1967. Cet accord encadre les activités de l'UNRWA dans le territoire palestinien occupé, mais également celles en lien avec celui-ci. Certaines de ces dispositions évoquent en effet l'entrée des véhicules et du personnel de l'Office en Israël. L'autorité palestinienne a également conclu divers accords avec l'UNRWA, dont un accord relatif à l'emplacement de son siège en Cisjordanie et dans la bande de Gaza, signé à Ramallah le 5 juillet 1996. Le 28 octobre 2024, la Knesset a adopté 2 lois visant à interdire les activités de l'Office en Israël et par une extension contestable de son droit interne dans le territoire palestinien occupé. Cette législation a entre autres donné lieu à une notification adressée à l'UNRWA le 3 novembre 2024, par laquelle Israël estime résilier l'accord de 1967. De l'avis de la France, le principe général du consentement des parties intéressées par les activités de l'UNRWA doit s'articuler avec les autres obligations internationales qui pèsent sur Israël dans le territoire palestinien occupé d'une part, sur son propre territoire d'autre part. J'évoquerai ces 2 aspects successivement car l'articulation n'est pas la même dans les 2 situations. Tout d'abord, dans le territoire palestinien occupé. En tant que membre des Nations Unies, les marges d'appréciation d'Israël pour interdire les activités de l'UNRWA sont d'abord encadrées par son obligation générale de coopérer de bonne foi avec l'ONU. Cette obligation découle notamment de l'article 2, paragraphe 5 de la Charte, qui énonce que les membres de l'organisation donnent à celle-ci pleine assistance dans toute action entreprise par elle, conformément aux dispositions de la présente Charte. Comme le souligne son chapeau, la mise en œuvre de cette disposition est une condition nécessaire à la réalisation des buts des Nations Unies qui sont énoncés à l'article 1er de la Charte. On rappellera à cet égard que l'ONU a, parmi plusieurs objectifs, celui de réaliser la coopération internationale en résolvant les problèmes internationaux d'ordre notamment humanitaire. La Cour a très tôt retenu une lecture large du devoir d'assistance des États membres en l'appliquant aussi aux actions de l'Assemblée générale, même si ce devoir ne saurait avoir pour conséquence juridique de conférer une valeur obligatoire à ce qui est une recommandation. De plus, l'obligation d'Israël de coopérer avec l'ONU dans le cadre spécifique de l'assistance humanitaire à Gaza a été rappelée à plusieurs reprises par les organes des Nations Unies. Par exemple, dans son ordonnance en indication de mesures conservatoires du 28 mars 2024, qui produit encore des effets à ce jour, votre Cour a enjoint Israël à prendre toutes les mesures nécessaires et effectives pour veiller sans délai, en étroite coopération avec l'Organisation des Nations Unies, à ce que soit assurée, sans restriction et à grande échelle, la fourniture par toutes les parties intéressées des services de base et de l'aide humanitaire requis de toute urgence. Israël se trouve donc dans l'obligation de donner pleine assistance aux actions de l'Office dans le territoire palestinien occupé, ce qui implique a minima l'obligation de ne pas entraver ses activités. S'agissant maintenant du territoire d'Israël à proprement parler. Les obligations d'Israël à l'égard de l'UNRWA dans le territoire palestinien occupé sont à distinguer de celles concernant la présence de l'Office sur le territoire israélien en tant que tel. Dans son avis consultatif relatif au siège de l'Organisation mondiale de la santé en Égypte, la Cour a reconnu le pouvoir souverain de décision d'un État pour ce qui est de la présence d'une organisation onusienne sur son territoire. Le retrait du consentement d'un État à cette présence procède de ce même pouvoir souverain de décision. Cela dit, ce pouvoir est encadré par les obligations dues à l'ONU par un État membre en cas de dénonciation de l'accord relatif à la présence d'une organisation onusienne sur son territoire. Ces obligations ont été détaillées par la Cour dans son avis précité. Celui-ci est tout à fait transposable en l'espèce, étant donné notamment que l'accord de 1967 est silencieux quant à ses modalités de dénonciation. En vertu de ces obligations, Israël et l'UNRWA doivent d'abord négocier de bonne foi les conditions de transfert des activités de l'Office en dehors du territoire israélien. Israël doit ensuite accorder une période de préavis raisonnable à l'Office pour préparer son départ. Et enfin, lui octroyer, ainsi qu'à son personnel, les privilèges, immunités et facilités nécessaires au bon déroulé de la présence transitoire, la période transitoire. En outre, l'exercice par Israël de son pouvoir de retirer son consentement à la présence de l'UNRWA sur son propre territoire exige de tenir compte des conséquences d'une telle décision sur le territoire palestinien occupé. Il s'agit en effet d'une décision ayant des conséquences en lien avec le territoire palestinien occupé, au sens de la question posée à la Cour. De nombreuses activités de l'UNRWA dans le territoire palestinien occupé dépendent en effet de facilités ou d'autorisations délivrées par Israël sur son propre territoire, y compris pour tout transit vers ou depuis le territoire palestinien occupé. La suppression de ces facilités pourrait entraver concrètement et durablement l'accès physique au territoire palestinien occupé et donc la capacité de l'UNRWA d'y opérer. De telles conséquences seraient de toute évidence incompatibles avec l'obligation d'Israël de ne pas entraver les actions de l'Office sur le territoire palestinien occupé identifié précédemment. Cette obligation doit donc également être considérée comme encadrant le pouvoir souverain de décision d'Israël vis-à-vis de la présence et des activités de l'UNRWA sur son territoire. J'en viens maintenant à l'obligation de respecter les privilèges, immunités et facilités de l'UNRWA. L'article 105 de la Charte des Nations Unies et la Convention sur les privilèges et immunités des Nations Unies, que j'appellerai ci-après la Convention générale, précisent les privilèges, immunités et facilités qu'Israël doit reconnaître à l'ONU ainsi qu'à son personnel. Il convient de relever que le champ d'application de la Convention générale a été explicitement étendu au territoire palestinien occupé par l'accord de 1967. Toutefois, à supposer que cet accord soit considéré comme ayant été régulièrement dénoncé, la Convention générale resterait applicable à l'égard de l'UNRWA tant en Israël que dans le territoire palestinien occupé. En effet, si l'article 105 de la Charte fait référence au territoire de chacun de ses membres, les dispositions de la Convention générale, qui est communément considérée comme une ampliation de l'article 105, sont-elles rédigées en des termes particulièrement ouverts. Elles évoquent par exemple les biens et les avoirs de l'ONU où qu'ils se trouvent et quel que soit leur détenteur, à la section 3. L'objet et le but de la Convention générale est de protéger les avoirs et les agents de l'ONU en vue de permettre à celle-ci d'exercer efficacement les missions pour lesquelles ses membres l'ont mandaté. De fait, il serait paradoxal et contraire à l'objet et au but de la Convention de priver l'organisation de toute forme de protection au motif qu'elle agirait en territoire occupé. et ce alors même que c'est un territoire sur lequel elle exerce une responsabilité particulière. Par conséquent, Israël est dans l'obligation d'appliquer la Convention générale dans le territoire qu'elle occupe, même en l'absence d'accord spécial dans ce sens. Je traiterai maintenant et successivement des obligations d'Israël issues du droit international humanitaire, premièrement, et du droit international des droits de l'homme, deuxièmement. En ce qui concerne le droit international humanitaire, la France souligne à titre liminaire qu'Israël a, comme d'ailleurs tous les États, l'obligation de respecter et de faire respecter les conventions de Genève en toutes circonstances. De plus, comme la Cour l'a rappelé dans son avis rendu en juillet 2024, ni la durée ni l'illicéité de l'occupation israélienne en Palestine n'ont pour conséquence de dégager la puissance occupante de ses obligations à ce titre. Dans ce contexte, je me limiterai à détailler deux obligations. La première de ces obligations est celle d'assurer et de faciliter la fourniture sans entrave d'articles de première nécessité essentiels à la survie de la population civile. Elle trouve son origine dans l'article 59 de la 4e Convention de Genève, à laquelle Israël est partie, et qui s'applique à l'ensemble du territoire palestinien occupé, y compris Gaza, comme votre Cour l'a rappelé dans son avis de juillet dernier. La question de l'application de cette disposition se pose avec une extrême gravité, au moment même où les présentes audiences se déroulent. À Gaza, l'entrée des camions d'aide humanitaire est totalement suspendue depuis le 2 mars. Les organisations internationales encore sur place nous alertent sur l'épuisement des stocks alimentaires ainsi que sur les multiples pénuries de médicaments. Je relève qu'en Cisjordanie aussi, la multiplication des contrôles entrave quotidiennement l'intervention des organismes humanitaires. L'article 59 impose à la charge de la puissance occupante deux obligations, auxquelles elle ne saurait se soustraire dès lors qu'il est établi que tout ou partie de la population du territoire occupé est insuffisamment approvisionnée. Dans ce cas de figure, la puissance occupante doit, d'une part, accepter l'aide humanitaire. Il s'agit là d'une obligation de résultat. La puissance occupante est tenue de n'opposer aucun refus à l'aide humanitaire. D'autre part, la puissance occupante doit faciliter l'aide humanitaire dans toute la mesure de ses moyens. En vertu de cette obligation de comportement, la puissance occupante doit de bonne foi mettre en œuvre tous les moyens à sa disposition pour faciliter l'acheminement de l'aide qu'elle aura acceptée. L'article 59 est formulé en des termes qui permettent de viser tant les secours collectifs fournis par les États que ceux dispensés par les organismes humanitaires impartiaux. Pour autant, il ne donne aucune liste limitative des organismes pertinents dans ce cadre. En principe, une puissance occupante dispose donc d'une marge d'appréciation dans le choix des organismes capables de fournir l'aide nécessaire à la mise en œuvre de cette disposition. En pratique, néanmoins, une puissance occupante est tenue de prendre en compte les circonstances propres au territoire qu'elle occupe, afin d'autoriser et de faciliter les activités des organismes humanitaires adéquats, c'est-à-dire ceux qui sont en réelle capacité de fournir l'aide suffisante à l'approvisionnement de la population locale. Enfin, il convient de souligner que l'article 59 contient en effet une clause de sauvegarde permettant notamment à la puissance occupante de vérifier les envois et de réglementer leur passage selon des horaires et itinéraires prescrits. Si, en application de cette clause, des contrôles peuvent être justifiés, la France rappelle qu'ils ne peuvent aboutir à empêcher l'aide humanitaire. Cela viderait l'article 59 de sa substance. En l'espèce, il convient de tenir compte du fait que l'UNRWA est le principal pourvoyeur d'aide humanitaire et de services essentiels dans le territoire palestinien occupé. En outre, la France relève que l'UNRWA, pour bénéficier de ces dispositions, doit être un organisme impartial, au sens de l'article 59. Dans ce cadre, la France a pris note des conclusions du rapport Colonna sur l'adhésion de l'UNRWA au principe de neutralité. Elle souligne que l'Office s'est engagé à le mettre en œuvre, ainsi qu'à continuer à appliquer une politique de tolérance zéro à cet égard. Ces circonstances, couplées à l'état catastrophique de la situation actuelle, réduisent significativement les marges d'appréciation d'Israël dans l'exécution de son obligation au titre de l'article 59. En effet, en l'absence d'autres acteurs en capacité suffisante d'assurer de manière effective l'approvisionnement adéquat de la population, Israël est tenu, en tant que puissance occupante, et tant que cette situation perdure, d'autoriser et de faciliter les activités de secours de l'UNRWA dans le territoire palestinien occupé. La seconde obligation incombant à Israël en tant que puissance occupante est celle de protéger les travailleurs humanitaires. Pour que l'aide humanitaire soit effectivement fournie aux populations civiles, la sécurité des personnels travaillant pour l'organisme pourvoyeur de cette aide doit être assurée sur le terrain. Et les parties au conflit doivent conduire les hostilités en tenant compte de cette protection. L'obligation de protection des travailleurs humanitaires peut à ce titre être considérée comme le corollaire du droit de la population civile d'être secourue. Prévue par le droit international coutumier, la règle selon laquelle le personnel de secours humanitaire doit être respecté et protégé est en outre régulièrement rappelée par le Conseil de sécurité. Ce rappel paraît d'autant plus nécessaire que, selon le Bureau de coordination des affaires humanitaires des Nations Unies, il y a eu, au 22 avril 2025, au moins 418 travailleurs humanitaires tués dans la bande de Gaza depuis le début de la guerre en octobre 2023, comme je l'ai déjà indiqué. Dans ce cadre, la France réitère sa condamnation des tirs israéliens sur les ambulances qui ont tué 15 secouristes du Croissant Rouge palestinien, de la Défense civile et de l'UNRWA à Gaza le 23 mars 2025. J'en viens maintenant à l'obligation d'Israël de respecter le droit international des droits de l'homme dans le territoire palestinien occupé. Comme la Cour a déjà eu l'occasion de l'indiquer, les obligations d'Israël découlent entre autres des deux pactes de 1966, ainsi que de la Convention des Nations Unies relative aux droits de l'enfant. En outre, la Cour a déjà rappelé que la protection offerte par les conventions régissant les droits de l'homme ne cesse pas en cas de conflit armé ou d'occupation. De fait, à l'obligation d'Israël d'assurer un accès humanitaire au titre du droit international humanitaire, s'ajoutent diverses obligations tirées du droit international des droits de l'homme. Au regard du risque grave et imminent de famine auquel sont confrontés les civils palestiniens à Gaza, je mettrai l'accent sur le droit à la santé et le droit à une nourriture suffisante. Conformément à l'article 2, paragraphe 1 du PIDESC, chaque État partie s'engage à agir, tant par son effort propre que par l'assistance et la coopération internationale, en vue d'assurer progressivement le plein exercice des droits reconnus dans le présent pacte par tous les moyens appropriés. Par conséquent, si l'aide humanitaire est dans une situation donnée indispensable à la réalisation des 2 droits susmentionnés, un État doit considérer cette aide comme un moyen approprié à leur réalisation au sens de cette disposition. Au vu de la situation insoutenable dans laquelle se trouve la population civile palestinienne, il ne fait aucun doute que l'aide humanitaire peut être qualifiée de mesure propre à la mise en œuvre par Israël de ses obligations au titre du PIDESC. En outre, dès lors que cette aide s'avérerait essentielle pour la jouissance par les Palestiniens de leurs droits fondamentaux, Israël ne pourrait en restreindre l'accès sans agir en violation des obligations susmentionnées. Monsieur le Président, Mesdames et Messieurs les juges, il découle de l'ensemble de ces éléments qu'Israël est dans l'obligation, au regard de la situation humanitaire critique dans la bande de Gaza, d'y autoriser et d'y faciliter la présence et les activités des acteurs humanitaires, en particulier de l'UNRWA. Pour conclure, la France réitère son appel aux autorités israéliennes à mettre un terme à la situation humanitaire dramatique à Gaza. À cette fin, elle appelle Israël à coopérer avec ses partenaires internationaux, y compris l'ONU, afin d'assurer de toute urgence l'accès et la sécurité des opérations humanitaires dans la bande de Gaza et l'ensemble du territoire palestinien occupé. Je vous remercie pour votre attention.
Je remercie le représentant de la France pour sa présentation. Before I invite the next delegation to take the floor, the court will observe a coffee break of 15 minutes. The hearing is suspended.